Welcome back to the Legal Roundtable here on the Oscar Pistorius Trial, a carte blanche channel. I'm joined in the studio by tonight's legal experts. We have former High Court Judge Chris Greenland, Professor James Grant from Wits University, and Defence Attorney Clifford Alexander. And we have some very interesting legal issues to talk about this evening. I think you're going to find this quite intriguing. Gentlemen, welcome to all three of you. It's good to have you all back again. Cliffy, I'll start with you at the end there. What was the value of the evidence that we heard today from Johan Stander and his daughter Carice?
Dave, yes, I think Professor will get to it just now, but with all due respect, your guess is as good as mine as to why it was led. I believe, and the Professor will expound on it, it was a good way to get inadmissible evidence admitted. And perhaps we can go straight over to the Professor in that regard.
Okay.
So he's burning.
You can come and take over this chair if you like, Cliffy.
Good gracious.
There are, in fact, I know the judge has also got some, before we get into this issue that Cliffy is taking us to quite immediately, Judge, you've got some interesting observations about the value of this testimony today. What are your thoughts?
I think that the evidence about Oscar's emotional state was to lay a foundation for the argument that that emotional state, that level of trauma that he displayed after the shooting is only consistent with an accidental shooting. I think that's...
So this wasn't the demeanor of a man who calculatedly and intentionally killed another person. This was the demeanor of a man who realizes the awfulness of a mistake.
Yes, that's what the argument will be, that a person in that emotional condition is not a killer.
Yes.
Is not a person who has just killed somebody in cold blood.
Does that make sense, Cliffy, to you? Do you buy that as the value of testimony?
No. From a defense perspective, and the judge would have been there, of course, to decide whether or not we were speaking sense or otherwise, and I'm sure that the judge would have pointed out to us that we were talking nonsense or not. But yes, to an extent I do agree with the judge, yes. Of course, the counter-argument would come in that he could have raised that defense at any time. It could be that he was showing remorse at what he realized that he'd done as per his testimony, that there's the gap missing. We're not too sure exactly what his version is. We've heard various versions from Oscar, and that after he realized what he had actually done, then he was remorseful. But at the time that he committed the act, which it is alleged, he wasn't remorseful at that time. There's various arguments, but I hear what the judge is saying.
So is it these, when I look at the words that Johan Stander was using, this is what the defense wanted, if the judge's observations are correct, where he was talking about him being torn apart, broken, desperate, pleading, begging her to stay with her, and then Stander says, I saw the truth there this morning and I feel it. That's what the defense wanted from their witness, isn't it?
Exactly.
Yes. Yes, and possibly no.
Let's go for the no part. The yes part's quite obvious. What's the no part?
Let me agree with the judge and with Cliffy to say that I think there is an extent to which the testimony as to his emotional state could have been about saying this is inconsistent with somebody who had just committed premeditated murder. But it might be consistent also with somebody who has just committed premeditated murder and just realized the awfulness of their deed, right? Setting that aside, the whole tenor of the two witnesses today seemed to be about testifying as to the fact that immediately upon discovery, Oscar said exactly what he is now saying or what he just said before the court, which is, I mistook Reva for an intruder. Now,
in fact, he didn't say mistook. He said, I thought.
Correct. I thought she was
an intruder.
Correct. Pick me up. I thought she was an intruder. Now, the extent to which they are seeking their witnesses, or in fact got their witnesses to say that, it's evidence of a previous consistent statement. Now, the moment that happens in a court, it's inadmissible. Evidence of a previous consistent statement is meaningless. If I was, for instance, to rob you and run outside of the studio and say immediately as I got out of the studio, I robbed no one, I'm then arrested, brought to trial, and in that trial, On the stand, I say, I robbed no one, and then I seek to bring a witness evidence of a security guard who saw me exit the studio saying, I robbed no one. I'm not allowed to bring that evidence because it's meaningless. The point is, and this is the attitude that our law has taken, if it's a lie, it can be repeated as many times as you want. It doesn't change, a lie doesn't change from being a lie to being the truth just because you repeat it.
Because you've got witnesses saying that you said that.
Yes. Now here's the difficulty. It was unopposed. There was no objection to this at that level, right? There's the evidence of his emotional state is one thing, and it can cut both ways. But the evidence of the previous consistent statement could possibly have been objected to by Nell. In the absence of that, it remains inadmissible evidence. The judge then, well, let me leave this to the judge. What should the judge have done?
What should the judge have done, Chris?
I'm glad that Prof has explained this so clearly, and it's quite simple. Evidence of previous consistent statements are inadmissible, and therefore not evidence. Anything that's not evidence should not be admitted. So I agree with Prof. And I can only think, suppose, or imagine that the presiding judge will deal with this. And if I was in her position, I would give counsel notice that I intend to instruct my assessors and instruct myself to ignore that evidence or ignore that statement, evidence of that statement, because Prof is quite right, it's inadmissible.
The interesting problem.
And if it remains, if it remains on record and regard is had to it, that would be irregularity, a material irregularity in the trial.
But is this not something you would expect a judge to raise in court so it becomes part of the court record?
Absolutely. It just struck me. It's just evidence that I think on my feet, right?
Okay.
The judge could do this, which would be very clever maneuvering. The judges could take it into account, but attach to it so little weight as to say, in fact, it matters not and it doesn't contribute to anything in my deliberations. It's a way, if there was an oversight here, let me say a big if there was an oversight and she realizes it later, she can reduce its value to the point where it doesn't matter.
I understand the concept of a previously consistent statement being inadmissible. How then, though, if somebody's defense is putative private defense, how do you then get other witnesses to back your version, to bolster your version, other than by repeating the kinds of statements that you are making, like, I thought it was an intruder? Is that not a highly relevant statement for anybody who's arguing putative private defense? You'd want as many witnesses as possible saying, he was telling us that seconds after the shooting. It could not be a concocted evidence that he thought of, dreamed of, when he was sitting saying, I'm in deep trouble now, how do I get myself out of it?
I'm going to say one last thing and then hand over because I've said enough. What do you suppose, I expect Nell would argue this, what do you suppose somebody who commits premeditated murder plans to do and to say to those people who come upon him immediately after the crime?
If it was concocted, now the defense is saying this is not concocted, this was a reality, a genuine, immediate emotion.
David, the fact of the matter is that this can arise in virtually any situation where a crime has been committed. It's always in the interests of the accused, the guilty accused, to be able to say things that are consistent with his innocence and then call witnesses to say that. That is precisely why the law disallows it.
Okay. Cliffy, what do you make of this whole issue of the previously consistent?
Harry should, with all due respect, have stood up and objected right from the start. We're quite surprised that he didn't. He let it go. The relevance thereof as well, apart from the admissibility. I believe, as Prof and the judge have both said, the probative value thereof, I think, is going to come to almost null.
Yes.
In the finding, whichever way it goes.
So it might be dealt with later by the judge. Of course, Harry Nell still has Carice Viljoen on the witness stand, or does he?
No, he's finished with her.
That's right, he's finished with her. Of course, they're going to move on to the next witness. Yeah. I beg your pardon. So that opportunity has now fallen away. It's now up to the judge to take some kind of action on this. There were, sorry,
David,
Chris,
the problem with it, although I agree with what Prof has said, the problem with this solution that we have cooked up here is that it's a good legal solution, but to the man in the street, ordinary human beings. That evidence is very, very, that statement
Yes.
is very, very powerful
Yes.
in Oscar's support,
Yes.
in Oscar's favor.
That's right.
So we'll have this unhappy situation where, from the public's point of view, this absolutely shows that Oscar is innocent,
Made a
that he's
mistake.
telling the story, he's telling the truth when he said he made a mistake, and the court saying, well,
We can't use it.
not only that we can't use it, but it's of little.
Of little value.
Yeah.
Okay,
You
I
see,
understand.
that's the problem I have with it.
Okay, very interesting conundrum raised there. Remember, you can join us on Twitter, Facebook, Instagram, and WeChat. You can search for Oscar Trial 199. A little later on in the show, we'll look at some of the tweets that you've sent to our legal panel, and we'll be back right after the break.
Remember to vote for your favorite Survivor South Africa Champions captain via SMS, WeChat or online. Voting is now open and closes Wednesday, 14 May.
Survivor South Africa is proudly sponsored by Outsurance. You always get something out.
As long as we made money, we are happy with that. Redefining the traditional concept of power.
And what it takes to be a CEO.
It's all, of course, got to do with money.
CNBC Africa. Your channel.
Brace yourself. For Vodacom Super Rugby. Exclusive to Supersport on DSTV Premium. Broadcast brought to you by Vodacom.
Prepare yourself.
It's time for a new course of action.
Just do what you have to do.
I come to win.
And if he loses,
Unthinkable.
Game on.
Weapons tight. Light him up.
oh my God, he's a monster.
Welcome back to the Oscar Pistorius Trial channel. If you have questions for my guests, tweet them to us using the hashtag Roundtable199. We'll continue tonight's roundtable debate with former High Court Judge Chris Greenland. We have Professor James Grant from Wits University and defence attorney Clifford Alexander with us here in the studio. There was a question we were debating about who was first on the scene immediately after the shooting, and our understanding was that it was Carice Viljoen, simply because she walked in ahead of her father. But now we suddenly find there's a man called Frank Tusiweni, who's Oscar Pistorius' gardener, who was also on the scene first. Is this a bit of a surprise that there's this new name and a man who is closer to the action than anybody else? He lives on the property. One would anticipate surely at some stage he'd be called, wouldn't we?
Yes, if he had something, I believe, relevant to add to the proceedings, I believe that Captain Mike van Aert, who's a thorough investigating officer, would have consulted with him already and determined whether or not he had anything to add thereto. If not, I
suppose we get asked the questions about why such and such evidence wasn't led. Why is this person not giving evidence? Why the evidence about the dogs not becoming relevant? And each time the answer is because they've worked out it's not going to be of any assistance. Would that be fair to say?
Yes. Yes. The witness's evidence, a statement will have been recorded from him, and an assessment will have been made by the state and the defense as to whether this helps their case.
Yes.
And if it doesn't, the witness falls out.
What did you think of the style of cross-examination by Gerrie Nel? Not as hard as we've seen with other witnesses, Chris.
I was now impressed. I think I previously said on your program that I prefer that style of cross-examination. Good bedside manner, but clinical, like a good surgeon.
Yes.
Rather than the bombastic steamroller type of cross-examination.
I thought we were
I thought today he was brilliant.
I thought we saw signs of the old Gerrie Nel when he pointed out in the comment by Johan Stander about what Oscar had said to him in that initial phone call, the previously consistent statement that should not be allowed, as we now find out. But he used the words, "I made a mistake." Now, he was carefully grilled on that one. Why was that significant for Gerrie Nel to pick up on that point?
Go for it, Prof.
I think what he was drawing attention to is that the witness was drawing an inference. That's one possible interpretation. That's my interpretation, and it's not allowed. Witnesses are there, ordinary lay witnesses are there to testify about the raw data, the information, not to be drawing inferences. That's the court's jurisdiction. Alternatively, when you have experts are allowed to venture into that domain. So it was really picking him up on the fact that he was showing, and Nel was showing, that this witness is actually not giving you the raw information, judge and assessors. This witness is actually manipulating. Even at a subconscious level, it might have been entirely an honest mistake, but this witness is manipulating the raw data as he's presenting it to you. I think that's the best interpretation that can be placed.
Yes, I think in simple terms, it's the standards versus the sticks, is it?
I'm glad you're looking that direction, not towards me. on the events immediately after the shooting. Yes.
And the issue that then arises is who of these two sets of witnesses are more reliable? And obviously witnesses who can be described and categorized as independent are more reliable. And what Gerrie Nel did at a stroke, and I think masterfully, he showed that witness was suffering from at least subconscious bias because of the way she then changed the evidence. Included.
It was the father.
He included this extra bit.
Yes.
In order to favor Oscar. And people do that when they're being honest, but they're not independent. They suffer from what's called subconscious bias, and therefore they're less reliable. So I think Gerrie will be able to argue that they're not as independent as the competing witnesses.
So it was a critical mistake that was made there. I'm sure for the defense they would have actually then been a little disheartened by that particular moment.
Gerrie scored a good point there.
In terms of subconscious bias, James, you've raised another point before we came on air about the judge who will be subject to this barrage of media. And even if she doesn't turn on a television, doesn't read a newspaper, and I gather from her own comments she doesn't know about Twitter or Facebook or anything like that on her own version right at the beginning of the trial, she at least will see signposts and she will be subject to some form of media about this trial.
Yes.
I know your colleagues have expressed a concern about
this. Correct. The godfather, I think he wouldn't mind being called this, of the law of evidence in South Africa, David Zeffert.
Yes, everybody who knows law knows David Zeffert's name.
Gave me a call last week to say, and I thought I was in such trouble, I'd said something wrong. You don't want to be in trouble with David. But he said to me, he has a concern, and he wouldn't state it any more strongly than that. He has a concern about to what extent a judge at a subconscious level could possibly ignore what he called the tsunami of media attention around this case. When she drives home, she passes signposts. She has to virtually ignore the news, any newspapers, magazines. And his point wasn't that she could possibly be consciously misdirected, but he was raising, at least for me, the very real question of what is the risk of subconscious influence. Now, here's where the penny dropped for me, is when you take David's question and you put it together with research done by Kahneman and Tversky on judges. They took 50 judges.
Yes.
And they put to them a scenario where the appropriate sentence would be between 1 and 6 years. And they said to them, judges, here's a dice. I want you to throw this dice and see how it comes up, and then hand down your sentence.
So they considered the facts of the matter, they considered the law.
Then they were given this dice.
Okay.
They didn't know that the dice had been rigged. It would come up either as a 1 or a 6. Now, when it came up as a 1, there was a significant lowering of the sentence. When it came up as a 6, the sentence given was significantly, statistically higher.
Okay, so there's a subconscious bias based on the dice. Judge,
I think I can.
How do you answer? Help me.
I think I can only base this on my own experience.
Yes.
I was involved as an assessor in the most sensational, high-profile trial in Zimbabwe when the ruling party's president was put on trial for the killing of a white farmer, State versus Tikere. And the media coverage was wall-to-wall, just as we have in this Oscar Pistorius case. And I can assure you that that didn't influence me or the other members of that court one jot.
Yes.
So I think where it's dangerous is, if we take this case for instance, let's say it was reported in the media, headlines, Oscar admitted killing Reva because he had seen a message on her cell phone from an ex-lover.
Yes.
Now, I would agree with Prof 100%. As a human being, that will induce subconscious bias. It'll be almost impossible for me, as a presiding judge, to disabuse my mind as much as I will consciously, but subconsciously. When you're weighing up, if things are in a balance, subconsciously, that's going to affect you. So to that extent,
but to that extent, with all due respect to both the judge and the learned Prof, the fact that the presiding judge, who has conducted herself in an extremely professional manner to date, as of the assessors, doesn't even know that we have elections on Wednesday, shows that she's not following the news. And I say that with the greatest
in fact, that's what I was going to suggest, is she is so insulated.
She's in a cocoon.
That it came as this enormous surprise to her that it was a public holiday on Wednesday.
Indeed. I think very professional.
She's not following, and I think it's going to be hard to penetrate.
I think there's no question about her conscious mind.
Yeah.
My concern is the subconscious.
But that's inadmissible.
We'll take a break. We've got all of your tweets still to come. In fact, we've got loads of those. You can keep them coming. If we don't get through them today, we'll certainly tackle them tomorrow on the Legal Roundtable, and we'll continue this discussion right after the short break.
This is the cosmos, a network of 100 billion galaxies. And it's the greatest story science has ever told. Come with me. Our journey is just beginning.
Knowing news first makes all the difference. News 24. Breaking news first. Visit news24.com online or on your mobile phone to access breaking news anytime, anywhere.
Flying car. That's what we go with.
When you think outside the box, even the dead can come back to life.
I think he's been lobotomized.
It's time to uncover some living secrets.
Everything in our experience tells us they're dead, all four of them.
No screwing around.
Where is she?
CSI Season 6, Tuesdays at 8 on Sony Entertainment Television.
We've got a little bit of this and a whole lot of that tomorrow, starting with Numbers, where one brother's detective skills are combined with the other's mad math skills to solve crimes. Forget about sitting on the fence. Why not straddle the Great Wall and listen to both sides of the story in Mao's Cold War? And then round off the day with some hair-raising recreations of animal attacks to show just how dangerous wild animals can be.
Welcome back here with Channel 199. Former High Court Judge Chris Greenland with us, Professor James Grant of Wits University, Defence Attorney Clifford Alexander as well. They're my guests. Let's have a look at the tweets, the questions that you've sent through to us. Hopefully we can answer as many of them as we can. When Oscar carried Reva from the toilet, did he not contaminate the crime scene, asks Rodney, who wants to field that one. We'll look at Clifford.
It can be argued that he did, but at that stage he wasn't charged for having committed an offence. It can be argued that he didn't.
It was all part of the act.
Indeed it was.
That's before the court.
It can be argued both ways. There's no evidence that he did.
If it was something deliberately done, I suppose, if he was carrying her through and he moved the duvet in that act or something.
If there was video footage, if there was a video camera in the room and it shows him doing it in a different story, but
yes.
At this stage, no.
But it hasn't been of any consequence here. It hasn't been questioned by Gerrie Nel in any way. It's not been addressed by the defence. So the answer to that one, it's not considered to be contamination in this particular case. Okay, Heartbreak Girl, so that Twitter handle is now gone, James. Is the verdict definitely going to be made next Friday? Because I have a party and I don't want to miss the verdict. It's not going to be made.
Go to your party.
You go to your party. What's going to happen is that we expect the evidence, the defence case, to be concluded by next Friday. And then what will happen, Cliffy? We'll have an adjournment.
Well, the way it was going today, is it going to be finished by next Friday? We don't know. But after that, it'll probably be postponed for heads of argument.
Heads of argument? How long would that... I know it's how long's a piece of string, Judge, but give us a ballpark.
If I was a judge, I'd give counsel 2 days, 3 days to prepare argument. And I would have the judgment ready within 3 weeks.
How long do you anticipate those final arguments to require in terms of Nel and Rue on their feet? A day and a half each?
Well, if it was heads of argument, with the greatest respect, it's heads, it's written argument. So there won't be an argument per se, oral argument.
But won't it be done? Surely it would be done orally, won't it?
It could be done, it could be read into the record, but in most instances it's considered read. In this particular instance, because of the media hype given to it, it might be read into the record.
Yeah.
What do you think?
I'm in preparation to argue.
Okay, so...
As a judge, I'd give counsel on both sides 2 days.
2 days
to prepare, to be ready to argue.
Okay. And then we'll have an adjournment and
for judgment.
For judgment.
Yeah.
How long for that? 6 weeks?
No, I don't
month?
think so. I think up to a month.
Up to a month, okay.
I don't know what you think.
So I think it's fair, Judge. We get 2 days, the judges get a month. That's about fair.
But it varies from judge to judge.
Well, I hope Heartbreak Girl's heart is now mended. She can go to her party. Is the trial a reality show or something? Because it's going on longer than expected. Well, it certainly isn't a reality show. It is the real deal that's going on there. But going on longer than expected, I think that is fair to say. It has gone on longer than expected, hasn't it?
It has indeed. I think if the judge had been presiding, and no criticism to the current presiding officer, he might have had some words to say on record.
Would you have cracked the whip on them, Chris?
No. I think the pace has been more or less acceptable. I'm not that happy about, for instance, today's adjournment.
Yes.
I think that, we have a backlog of cases in South Africa, and an inordinate amount of time has been lost in this particular trial. And what that means, in terms of the knock-on effect, is that there are so many other people waiting to be tried.
That's right.
So I don't think it's acceptable what happened today, that we lost half the day for no apparent reason.
Well, Larry Rue said he couldn't get hold of any more witnesses because of the public holidays, which I found quite remarkable, given that he had 2 weeks in which to line these people up.
Exactly.
It was like a naughty schoolboy saying, I'm sorry, it won't happen again. I suppose the judge's hands were tied, though, weren't they? Because there was no objection from the state. if a witness isn't there, there's nothing she can do.
But I'm told that she did ask them to see her in a chamber.
Oh, yes.
I'm hoping that that she would have taken stance.
There would have been stern words, do you think, in
I
chambers?
think so.
Let's move on. I was going to make another observation, but I think we've flogged that one. It's a mistake to have shot Reva through a locked door, but no mistake to shoot an intruder through a locked door. Confused, says Juanita. Unpack that for us.
I think it's quite simple. You cannot use that degree of force on a human being unless it's unavoidable. And unavoidable means that you must be under actual threat of serious injury or death, and you have no other cause of action. I think that sums it up.
So that would require knowledge that the person behind the door has a deadly weapon.
Well, then there's a practical problem. How do you know, even if he has a deadly weapon, how do you know that you are under imminent threat of serious injury or death? He might have a deadly weapon and he might have thrown it out of the window.
Yeah. I think if I can follow up on that and say that yes, it's a mistake, but it's an inessential mistake. It doesn't matter who was behind the door. What matters at the end of the day is whether Oscar believed that he was under attack and entitled to use that degree of force, lethal force.
Yes.
If he can establish that he believed he was under attack and entitled to use that degree of force, it's a complete defense to the murder charge.
Okay, so I think that's the critical point. Whether it's Reva or an intruder makes no difference. It's a human being behind the door.
If it raised the defence of putative self-defence.
Exactly.
Which we still don't know.
Which wasn't raised in the plea. Those words don't appear in the plea explanation, do they?
No.
Precipitated appears. The discharging of my firearm at the door was precipitated by the noises in the bathroom. What does precipitated mean? It's ambiguous.
Yes.
Preceded, premature.
Well, we'll wait to see how Barry Rue deals with that in his argument. The next question, can state appeal if Judge Masipa acquits Oscar? Will you answer at 8 p.m.? Well, we'll answer it now at 10 to 9. Can they appeal? Yes, of course.
State can appeal on sentence, state can appeal on questions of law, but there's a fundamental rule that once somebody has been in jeopardy, they can't ever be placed in jeopardy again. It's the double jeopardy rule. So if, for instance, Oscar is acquitted, the state can't call him to answer those charges again.
So obviously on sentence there's the issue. On the issue of fact, did you say?
Of law. So for instance, if the very boundaries of intention are mistakenly stated by this court and the facts are misapplied to the question of law, because the question of intention has been incorrectly framed, and because of that Oscar is acquitted, the state can then pursue and appeal against that because there's been a mistake of law. So the state can pursue and appeal questions of law or sentence.
Okay. I don't think we're going to have time to go to our second deck here. I think we've wrapped up.
Sorry,
Chris, you've got something else to raise?
Just before you go on, and I think as regards the sentence, it's important to point out that the state can, assuming the court imposes a sentence and Oscar appeals it, I think, Prof will correct me, the state can then cross-appeal and to have the sentence actually increased.
Oh, yes. Okay. As we have seen recently with the Minister of State Security's wife.
Frank Nabaliswa.
Frank Nabaliswa. That's right. And you know about that particular case. Okay. Well, we'll have to leave it there. Chris, thank you. James, Cliffy, always good to have you guys. And I'm sure we'll see you on the panel again in the immediate future. My thanks to my panel there, Chris Greenland, Professor James Grant, and Defence Attorney Cliffy Alexander. We'll have more from the Legal Roundtable tomorrow night. And remember, if you're not in front of your TV, Channel 199 is available online to qualifying DSTV subscribers. That full channel available 24/7 via live streaming to PCs and laptops at oscartrial.com. It's also available on your walker. From me, David O'Sullivan, good night. It's now over to Katie Katapodis.